So what I have for you today is an interesting case from Tanzania, which serves as a warning not to take anything for granted. The case is about Mlimani Holdings Limited, which was a local taxpayer, and as you can see in the background, there is a South African architecture consultancy called MDS, which helps, it seems like, businesses across Africa with their buildings. So if we look at the decision itself, it is in the Court of Appeal of Tanzania, and I think the judgments are from a decision of the tribunal of 2021, and this case itself is from 2022. So let's see what happened here. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. In terms of facts, it says between 2013 and 16, the appellant made payments to a South African entity, MDS Architecture, as we saw before, henceforth the foreign consultants, as service fees for architectural services to its projects in Tanzania. And then there was a 15% withholding tax due, which was not withheld because of the treaty. And the appellant, being the taxpayer, contended that it was exempt from a withholding tax by reason of Article 7 of the Double Tax Agreement. The respondent, which was the tax authorities, contended that notwithstanding the treaty, such payment was liable to deduction because it did not constitute a part of the business profits of the foreign payee. So the discussion here was whether the consultancy fees paid to MDT were business income or whether it was other income. And if we look at the treaty, the South African-Tanzanian Treaty, Article 7, says the profits of an enterprise of a country state shall be taxable only in that state, unless the enterprise carries on a business in the other country state through a permanent establishment situated therein. So this is standard OECD language, right? If the enterprise carries on a business aforesaid, the profits of the enterprise may be taxed in the other state, but only to the extent that it's attributable. And then it's got a bit of a deviant Article 20, normal OECD 21, very short, and it simply says item of income arising in the contracting state which are not dealt with in the foregoing articles of this agreement may be taxed in that state. So it's very a developing country perspective, leaning towards the UN model Article 21, saying that any other income the source state can tax. Now, if we look at the taxpayer, well, what the taxpayer argued is it said the reference was made to the principles governing interpretation of treaties, citing an excerpt from Judge Lord Jennings in Bulmer Limited versus S.A. Bollinger. We've not discussed that case on this channel before, for the proposition that such interpretation must look at the purpose as opposed to the words used. And so the part of the discussion in this case was whether you should follow the literal text as you do in law, or whether a treaty is open for different interpretation. And the taxpayer's lawyer also referred to Article 3.1 of the UN Convention on Law of Treaties on the approach towards interpretation of international conventions based on good faith and in accordance with the ordinary meaning used in their context and in light of objects of its purpose. And a lot of this case is about you need to, as court in Tanzania, follow the OECD guidelines and OECD commentaries. But the court relied on precedent and basically would have none of that, right? So the lawyer for the taxpayers, Mr. Ngowi, could not mince words responding to the court's questions or the correctness of the approach he was championing in the light of a decision of Kilembero Sugar Company, where basically the same issue was before the Tanzanian court, and the Tanzanian courts have decided that consultancy fees are Article 20 income because they service fees, they are not business income because basically because the word service is not defined in the treaty and therefore it must fall under the residual article. The lawyer was unrelenting in his oral address that the decision was erroneous, so this Kilembero decision, even though he did not give notice under Rule 106.4, and this we come back to this later. He invited the court in the course of a hearing to depart from Kilembero, and Rule 106.4 is a rule that says that if the lawyer wants the court to depart from precedent, he must warn the court before, so that the court is prepared. And we'll see what that means in the following arguments. The court itself rejected the argument and stuck with Article 20. So it said, as alluded earlier on, the interpretation of a double tax agreement is not new before this court. It featured as one of the interrelated issues for the court's decision in Colombero, where the applicant challenged the decision of tribunal, which, like here, made it a similar interpretation of the DTA. In other words, service fees fall under Article 20. That case involved a dispute over liability to remit withholding tax on service fees paid to a South African entity who had provided management services. It is apparent from the judgment that the learned counsel in Colombero had reinforced his arguments on the OECD commentary. So also in that case, the lawyer for the taxpayer said you need to have a look at the OECD model convention and the commentaries, right? And then they quoted Article 7 after revisiting the two articles. The court stated, following the above, as a service fee is an item which does not feature anywhere in a double taxation agreement, Article 20 becomes handy. It is our considered view that as per the double tax agreement, service fees by a South African entity for provision of professional services to a Tanzanian entity do not form part of business profits. So that was a Colombero decision, and then a few months later, a similar issue involving a dispute on the liability of withholding tax by another South African entity which had rendered service to a Tanzanian company arose in Mantra Tanzania Limited, and the court reaffirmed its position in Colombero, right? And so the court now refers to this Article 106.4, where it says that what the lawyer should have done is, where the parties intend to invite the court to depart from its own decisions, this shall be clearly stated in a separate paragraph of the submissions, to which special attention shall be drawn, and the intention shall also be restated as one of the reasons. So the court said, you should have told us that you wanted us to break precedent, and if we were warned, then we could have done the following. It said it is now settled that departing from a previous decision cannot be undertaken by an ordinary court, rather a full bench empaneled by 5 justices, which may intend overruling the previous decision of the court. So what the court said is, I'm a single judge, you come too late with this, you should have warned me before. I don't know whether the lawyer did or not, but this is not a 5-bench judge, and therefore I have to follow precedent, right? The above said, consistent with our decision in Colombero, we hold that the service fees the appellant paid to the MDS architecture did not constitute part of the business profits of the payee, and thus are liable to withholding tax in Tanzania. It is an unfortunate decision, I would say, because it clearly is in breach of what many other countries think the service fees and professional fees should be qualified as. But what I find interesting is also, you know, this is the way Tanzania look at this, right? If we look at Kenya, for instance, a similar issue played in Kenya, and I discussed this case on this channel before, and that was with McKinsey & Co. Inc. Africa versus the Commissioner. And again, there were management fees or charged, this time within the group between McKinsey South Africa and McKinsey Kenya. And again, the tax inspector argued that the service fees were subject not to Article 7, where he couldn't tax it because McKinsey didn't have a PE in Kenya, but under Article 21 in that case, because the service fees fell under other income. The inspector used clever arguments to get there, but have a look at that case if you're interested. What the court, however, said, the Kenyan court, is it said, since the Kenyan-South African double tax agreement does not provide for a definition of what amounts to a business, resort must be had to domestic law, because they looked at Article 3, paragraph 1, and said there was nothing in there. And then it said, you know, you need to follow our Article 3.2. And then the Kenyan Income Tax Act defined business to include any trade, profession, or vocation, and every manufacture and venture and concern in the nature of trade, but does not include employment. The services offered by the South African entity fall within the above definition and thus can be termed as income. Having determined that the service constitute a business, which is the appropriate article to deal with this, in this regard we are of review that Article 7 of the double tax agreement is the appropriate article, therefore, and there was no withholding tax due in Kenya. So clearly the Kenyan courts, based on this one decision, are more open-minded towards international tax developments than the Tanzanian courts. And it is interesting to see these two countries, how much they can differ in their interpretation, right? Because if we look at another decision from Kenya, in the Unilever case, which was transfer pricing between Unilever Kenya and sales made to a subsidiary in Uganda, the court says this about following, in this case, not the commentaries of the Moral Convention, but the transfer pricing guidelines and the interpretation of other countries' courts of the transfer pricing guidelines, including Indian courts. And it says, the judge says, I have noticed that the very lengthy submissions are made by Unilever Kenya on guidelines adopted by other countries have been ignored by the respondent, which is tax authorities, on the basis that these simply do not apply to Kenya. Now, these guidelines do not form the laws of the countries in question. They are simply guidelines, we're talking about the transfer pricing guidelines, guiding the world of business, that is, business enterprises and the taxing authorities of those countries in arriving at the proper transfer pricing principles for the purposes of computation of income tax. But then the judge goes on to say, I am therefore unable to accept the argument that in view of the alleged clear wording of Article 18.3, no guidelines are necessary here in Kenya. That is rather simplistic and devoid of logic. We live in what is now referred to as a global village. And I love this judge's expression of a global village. We cannot overlook or sideline what has come out of the wisdom of taxpayers and tax collectors in other countries. And especially because of the absence of such guidelines in Kenya, we must look elsewhere. We must be prepared to innovate and to apply creative solutions based on lessons and best practices available to us. That is indeed how our law will develop and our jurisprudence will be enhanced. And that is also how we shall encourage business to thrive in our country. So an interesting view, but one can also say about the Kenyan courts and especially the Unilever courts, there is this doctrine of common interpretation. Of course, when you look at treaties, it is wherever possible better to have a common interpretation than to have very divergent interpretations, because ultimately this is supposed to be a disagreement between countries and not an agreement between countries and not a disagreement. I think with regard to the particular case in Tanzania, two last thoughts. One is maybe the South African and the Tanzanian competent authorities need to get together under Article 25.3 and sort this issue on interpretation so that the business can do better going forward and the tax authorities can learn from whatever the joint decision is. And then finally, along the same veins, one wonder if you already had these precedents before the Tanzanian courts, whether this case would not have done better in a map between South Africa and Tanzania. I hope you enjoyed the case. It's something from a different part of the world. It is something showing how different countries can very differently interpret treaties. And I look forward to talking to you about more cases next time. Bye for now.